Ms. Hackle,
Hi. Hello. The authorized representative for Hackle is here.
please turn your camera on, please.
Okay, I have to access it, so it might kick me out. So I'm gonna do it now.
That's fine.
Okay.
I know I denied the motion to set aside the default judgment back on August 21st. Defendant failed to appear.
Correct.
Defendant's motion to seek leave of court is denied.
We're showing although this is a termination of tenancy for failure to recertify, we show a balance of in excess of $12,000.
Ms. Hackle, state your name for the record.
I am the authorized representative for Alicia Hackle.
I don't see your face. I'm sorry. I see your hat. Let me see your face.
Oh, okay, I'm here.
The camera's pointing at the top of your head. I can't see your face. All right. Mr. Hu, go ahead.
Yeah, thank you, Your Honor. A judgment was entered, a motion was denied, trying to set aside the judgment. Plaintiff is seeking a order of eviction for termination of tenancy. No payment has been made since March of 2024. We would ask that a writ be issued.
So the writ will issue and execute immediately.
Thank you, Your Honor.
I would like to say there's been a defective order of process. I never received a motion.
Welcome back to the channel, where today's docket is packed with drama, contradictions, and a little bit of comedy, whether intentional or not. We've got 3 cases that perfectly showcase the sovereign citizen playbook, and more importantly, how judges respond when patience runs out. First up, an authorized representative claiming to fight a squatter eviction with over $12,000 in unpaid rent. Next, a defendant who tried to dance around the right to travel fantasy, but quickly realized fixing his situation might only cost $50. And finally, one of the most decisive takedowns of sovereign citizen antics I've seen all year. Trust me, you'll want to stick around for that one. And while we break this all down, think about the bigger picture. What do these defendants gain by making things more complicated? And does it ever end well for them? Let's dive in.
Ma'am, what's your name? You said you're a representative for Alicia Hackle.
Yeah.
What's your name?
I never received the order of process for court today. I went down to the court today and she gave me the documents for court today. There's also isn't a sign off by a judge on the document that she explained to me that the judge didn't even sign the documents. I also never received a motion in the mail.
Well, this is an application. There is an application for eviction.
Yeah, there's an issuance for a writ here. I've actually never received that so that I could formally respond to it.
All right, so let me make a record. Give me 1 second.
Yeah, there should be some proof of service in the files for the case.
Well, hold on 1 second. 1 second. You were served with the summons and complaint. It was posted on the address by Court Officer Juan Polanco. I believe he did it on July 20th, 2024. And then there was a default judgment entered against you by Judge Goubeau on July 31st, 2024. I believe you failed to appear. You didn't appear to that. And so that's how we get here now. Then you filed a motion to set aside the default judgment. Hold on 1 second. And you did not appear to the default judgment. So yeah, the writ in issue. So you've been advised of court and you failed to appear twice. Like I'm not understanding what's going on.
Actually,
so the writ,
all my documents. I've given all my documents. There was a judgment issued against me, and it was denied. But and then after that, I hadn't received anything back for the case until I'm in court today about something that I had gotten no prior documents before I came to court today. I literally didn't receive any motion for issuance for a writ until today when I went to the court to get the papers. I didn't receive this by mail at all, so that I would have been able to respond to it before now.
Your Honor,
I
I
have
think
not
I
missed
heard
any
your,
case. I have not missed any court dates.
Your Honor, I heard your ruling. Thank you very much.
All right, thank you. We're all set.
Have a good day.
You too. Thank you. You got to move out, Miss Hackle. It's just that simple. Sorry.
This is where things turn quickly. The defendant claims the process is defective because they supposedly didn't receive notice. But here's the thing. The court record shows service was completed, a default judgment entered, and even a motion to set aside denied earlier. Judges don't just hand out eviction writs for fun. They follow a very specific process. When rent hasn't been paid since March and the tenant has already missed multiple hearings, it's not a surprise the writ issues immediately. Question for you all. Do you think defendants in these situations genuinely don't understand the process? Or are they just stalling for time?
Is that Mr. Myrick?
Yes, sir.
Okay. So, Mr. Myrick, good morning. I've got this set for a pretrial. Now, I have a note here that said that you were not interested in court-appointed counsel, which is fine. So, basically, at this point in time, it's a pretrial. So, I would set you up with a breakout room with the prosecutor to see, what if they have any offers or what their story is. I just want to make sure when you go in there, like you don't have an attorney with you and they're the attorney on the other side. They may give you an offer that you like, and that's fine. But I just want to make sure that that at any point in time, if you don't like the way the conversation is heading, if you change your mind and you do want to come back and ask for an attorney, just come back and let me know. Okay.
Okay. Before I get into the breakout, Your Honor, I do want to address we are in the pretrial stage, and in the arraignment stage, I was entered a plea involuntarily. So I would love to have an ample amount of time to draw a meaningful defense. If anything, there was some questionable things that the last judge mentioned that I haven't found at all as far as a statutory jurisdiction. But I would like to have time to draw a meaningful defense as well.
Okay, so do you not want to meet with the prosecutor then?
Well, I don't think it's completely prudent right now, simply because we haven't technically went past the arraignment stage of this process. I feel as if my due process has been violated, Fifth and 14th Amendment. I didn't enter a plea, and here we are in pretrial. So I would like to kind of digress a little bit and have at least enough time to develop a meaningful defense.
Okay, I guess I'm a little confused. So you had an arraignment date, and
Yes.
at that arraignment date, did you refuse to enter? Did you refuse to enter a plea? Because that's the time where a plea of some sort has to be entered. So at that point in time, did you, of your own volition, say, I'm not saying anything at all?
Well, that wasn't totally the case, but I didn't have understanding of what court I was in. And I didn't understand if it was a criminal jurisdiction, civil jurisdiction. And based on the at least the federal laws for sure, we didn't come up to an understanding. So
Notice how the story keeps shifting? First, it's I never got notice. Then it's I provided all my documents. Now it's I never missed court. But the record shows otherwise. Missed appearances, default judgment, denied motion. This is classic courtroom contradiction. When the paper trail says one thing, but the defendant tries to rewrite history live in front of the judge. What's fascinating is how calmly the judge handles it. Instead of blowing up, he just repeats the facts. Judges know that the record, not the excuses, decides the outcome.
Okay, so were you in, so just so I understand, were you in custody at the time you were arraigned? Were you in custody?
No, no, sir.
Okay, so how did you know how to even zoom in and get here?
Say that again, Your Honor.
How did you know, like for the arraignment, like so oftentimes when there's an arraignment that happens when someone's been arrested and they're sitting in custody, okay, or if they've received a ticket or some sort of notification. So you just said to me that you didn't even know what court you were in. So I just want to know, like, how did you know how to get here? How did you know how to zoom in? Because the
Oh, no,
Zoom
no.
information contains all of our like what court it is, what magistrate, like all that's contained in there. So I just how did you
Right.
know otherwise?
No, I did receive a ticket, and I got notice. But what my issue was appearing here on special appearance today, and I needed to get understanding of what jurisdiction I was in.
Okay. All right. So because I definitely want to make sure that people know where they're supposed to be. So I think I'm looking at the same ticket that you had. So it says on the ticket, 44th District Court, Royal Oak. And then the court address is on there. And then you said that you received notice. So the notice that went out, it would have had the Zoom instructions. Again, Mr. Myrick, as you can imagine, I'm always very concerned in making sure people have the proper notification and all of that. So it does appear that, I mean, you're here a second time. The only thing that I was, now looking at the file here, you were ordered to post a bond and you didn't. Now, I'm reading the notes here. It says there was a bond of 1,000 cash surety, no 10%. So $1,000 bond was expected to be paid within 48 hours. Now, Mr. Meyer, we're here today. You showed up on time. So one of the reasons that a bond is ordered is, one, for the safety of the community, and two, to a secure appearance. Well, you come here a second time, and so I am very comfortable that you are going to continue to show up. So I, at the very least, for you, Mr. Myrick, today, as long as you continue to abide by the expectation that you'll show up, and you have twice now, I'm going to actually amend that bond. So even though you were supposed to do it within 40 hours and you didn't, okay, the fact that you showed up here again, at least to me, is enough evidence to suggest that I can count on your appearance going forward. So
That's righteous.
Here we go again. The sovereign citizen strategy of questioning jurisdiction and refusing to acknowledge the arraignment. This is a move straight out of the special appearance playbook. They argue they never entered a plea. Therefore, the court can't move forward. But the flaw is obvious. By showing up, by receiving tickets, and by responding, they've already engaged in the process. Judges have heard this line countless times, and it never holds. Still, notice how patient the judge remains. He doesn't get baited into the circular logic. He just keeps asking simple, factual questions.
And what I'm ultimately asking, Your Honor, is that if I can have more time to, I don't have any discovery. I don't have what I need to assess to move forward. So if I can have more time.
I have no problem adjourning the pretrial so that you could do some more information gathering. Just to let you know, Mr. Myrick, again, like our court, as you can imagine, with 696-75 Woodward, we have a lot of traffic misdemeanors that come through this court. And one of our signature programs that we've been doing for the last 8 years is, trying to really help people, because I would imagine that you pay attention to the challenges of the Metro Detroit area and public transportation issues and people's ability to get around, and how many people over time have got themselves in the cycle of they have to drive, but they pick up a ticket and they can't pay that ticket, so the license gets suspended and they get stuck in the cycle forever and ever and ever. Okay. Well, in our Operation Drive program, what we've done over the last 8 to 10 years, we're keeping stats since March of 2016. So in the last 9 years, we're over 1,700 licenses restored. So like that's something that we try to do, is make sure that we inform, educate, get people the information that they need, which Mr. Myrick, you could probably imagine, for years and years, the court system hasn't been great about letting people know even where to start, how to get their license. So
Yes,
in the
sir.
meantime, while you're doing your investigation, I at least want to let you know what's on your record so that you can at least know, because some people don't even know like where to start, how to go, or what to
Yes, sir.
do. And
And I greatly appreciate you.
and the law has changed in a significant way. It used to be that every single little ticket that you'd get would suspend your license. Now it's only a couple tickets here and there that do that. So
I'm very honored, Your Honor, to be in your courtroom. I think you're the one that I've heard so much good news about, goodwill and good-hearted judge that assists the public to oppose to the opposite. So I truly appreciate your efforts here. Thank you.
This moment is interesting because the judge sees past the technicalities. The defendant failed to post the original bond, but the judge notices he's shown up twice now. That reliability matters. Courts aren't out to trap people. They want compliance, not chaos. So instead of punishing him for the missed bond, the judge adjusts it to a personal recognizance bond. That's not weakness, it's practicality. If someone shows they'll appear, there's no reason to keep unnecessary financial barriers in place. It's a subtle but powerful reminder. Courts often bend over backwards to be fair, even when the defendant is trying to fight
You're
the
thinking
system.
it's an NPOI?
yeah, it should be an MPOI.
All right. Because there
No
are
proof- no
three
proof
tickets, all of
insurance.
which are showing 45s. So let me-
Really?
Yeah. So let me look at the second one. Sorry, it's taking so long.
That's all right. That'd be great
All right.
news because that'd be just $45.
No proof of insurance. This one was a default judgment. It is showing $45. But it is showing a bond that you posted, sir, back in 2009 of $398. I think they took that, so perhaps they applied it to that fee, and they just want the 45. That may be the answer on that one.
So okay. So best case scenario, they'll let you just pay the 45. Okay. Worst case scenario, they'll want the $45 on each of the old tickets, so $135. So best case scenario 45, worst case scenario 135. But that's Allen Park.
Wow, that's great.
And that's 24th District Court, sir, if you're looking it up.
24th District.
And it's interesting because these are very old cases, but the close date on the third ticket is 2017, and now I'm getting error readings. So, but there's just 3. Looks like you had your bond taken on the no proof because perhaps you didn't go back, and that may satisfy that.
All right. So Mr. Myrick, so here's what we're going to do. I'm going to bump this out a couple weeks. You get to work chopping away at that kind of stuff. But I will say this. I only want to bump it out a couple weeks because if you get those things done, all right, I want you to come back and see me. We'll be able to run a new driving record. We'll see if by doing that, all right, that they follow through and let the Secretary of State know. Because if they take your money and they don't let the Secretary of State know, then the suspensions remain. And then we can even contact the Secretary of State and just make sure that they know, like, oh, by the way, he paid those.
Right.
And then when you come back here, you can give me an update. But just know, if you've paid those 2 tickets, you should be able to go to the Secretary of State and pay the reinstatement fee and go from there. So what do you think? A couple weeks?
Safely to say, I would say 30 days. If I can have the grace.
No problem. No problem.
Thank you, Your Honor. I appreciate you dearly too. Thank you very much.
You're welcome. All right, so we'll adjourn this 4 weeks, and we'll send notice again. And then just do me a favor, Mr. Myrick, if you run into issues, I'm gonna send you our direct line here at the court.
Thank you very much, Your Honor.
And for example, if you do decide, if you're running into issues, I certainly can connect with Mr. Angot, Ms. Chappelli there. Mr. Angot's our MIDC coordinator. I know that you initially were not inclined to go with assigned counsel, but what Ms. Chappelli's doing today is exactly what would be done. So if you just reach out to us, let us know, like if you're running into brick walls and you say, like, I would like an attorney attached to this case, then call us and we'll get it.
And here's the dramatic twist. After all the talk about jurisdiction, rights, and constitutional violations, the entire issue boils down to $45. Let that sink in. This defendant has been invoking sovereign citizen tactics, questioning the legitimacy of a court, and risking jail, all over a fine smaller than a dinner bill. The look on his face says it all. Sometimes the sovereign script is just a smokescreen to avoid responsibility. But when the actual numbers come out, the facade collapses. Audience question: do you think he'll actually pay this time or go right back to challenging the system?
Called People versus Ryan John Hart, file 24-4935FH.
Your Honor, Ryan Ziegler on behalf of the people.
Thomas Seeger appearing on behalf of Mr. Hart.
I have somebody in my hearing room listed as Ryan Hart. State your name for the record, please.
My name is Ryan John Family Hart.
I don't have anyone on my docket listed as Ryan John Family of Hart. I have an individual listed as Ryan John Hart. That's either you or it's not. You get to tell me whether or not that's your name. If it's not, then I need to call a different matter and bring somebody else into my hearing room.
Your Honor, I'm the representative of that entity, yes.
That's not an answer, sir. Your name is either Ryan John Hart, in which case you're invited to participate in the proceeding today as Ryan John Hart, or you're not Ryan John Hart, in which case I have no use for you to be in this hearing today. So.
Your Honor.